My name is Jerry Thornsberry, and I'm Chair of the City of Waterloo Board of Adjustments, and I'm calling the regular meeting of our board to order, and it's October 28th. And,
It's not.
oh, what is,
You're looking at
it's November 25th. Thanksgiving is around the corner. And with me tonight is Vice Chair
John Beckman. Board
Craig
member.
Holdeman.
and Board Member Craig Holderman. Yes, we have a quorum, and we have an agenda in front of us. Any modifications to the agenda? Hearing none, I would entertain a motion to approve.
So moved.
Second.
Moved and seconded. Any further discussion? All those in favor?
Aye.
Aye, motion carries. We have an agenda. We have the October 28th meeting minutes that was a part of our package. Are there any additions or corrections to those minutes?
Move to accept.
Second.
Moved and seconded. Any further discussion? All those in favor?
Aye.
Aye. Motion carries. And tonight we have 3 decision items. And the first one is a request by Kevin Rose for a variance to the accessory structure square footage limit to allow for a 1,308 square feet of accessory structure, 108 square feet more than the 1,200 square feet allowed, to allow for the construction of a 480 square foot addition to an existing accessory structure in the R2 1 and 2 family residence district located at 300 Blowers Avenue. Staff report, please.
This is Galman with staff. As stated, this is a request by Kevin Rose for a variance to allow for an addition to an existing accessory structure that will be 108 square feet more than the allowed 1,200 square feet at 300 Blowers Avenue. The property is 300 Blowers Avenue and is zoned R2 1 and 2 family residence district and has been zoned as such since the adoption of the zoning ordinance in 1969. The request would not appear to have a negative impact on the neighborhood as the addition is in the interior of the lot. The request would not appear to have a negative impact on traffic conditions in the surrounding area. The request would appear to conform with the classification of this area as low-density residential on the future land use map and the comprehensive plan. The section of zoning ordinance that pertains to this request is Chapter 5, General Regulations 10-5-1E, Accessory Structures. The applicant is proposing to add a 20-foot by 24-foot, 480 square foot addition to an existing garage. The applicant owns 3 lots, which combine for a lot area of 20,000 square feet. This puts the limit of the allowed square footage for detached structures at 1,200 square feet. If a restrictive covenant is signed and recorded, tying those 3 lots together so they cannot be sold separately. The addition would put the total accessory structure square footage at 1,308 square feet. The site plan shows the addition to be on the rear of the garage on the side further from the alley. The location will help keep the addition from being too noticeable. There's currently a trailer with a fence built around it directly behind the garage where the addition is planned. The applicant has told staff that the trailer will be removed from the property when the addition is built. There was a variance granted on January 28, 2020 to allow for the parking of 2 trailers related to a home-based business. This variance request was originally pulled from the October Board of Adjustment meeting by a request from the applicant to have it moved to the November meeting. When staff drove by the property this month, staff saw that the surrounding properties had junk in them and that the applicant's property was one of the best maintained in the immediate vicinity. Criteria: 1, lack of reasonable return. There would not appear to be a lack of reasonable return as the owner could build an addition that would meet the square footage requirements. 2, uniqueness. There would appear to be a uniqueness to the request as the property owned by the applicant is 4 times larger than the typical lot in this area. Public considerations: approval of this variance would not appear to have a negative impact on the surrounding area, and staff is not aware of any opposition to the request. Therefore, staff recommends that the request by Kevin Rose for a variance to the accessory structure square footage limit to allow for 1,308 square feet of accessory structure, 108 square feet more than the 1,200 square feet allowed, to allow for the construction of a 480 square foot addition to an existing accessory structure in the R2, 1 and 2 family residence district located at 300 Blowers Avenue be approved for the following reasons. One, there would appear to be uniqueness for the request as the applicant's property is 4 times larger than typical lots in the area. Two, the request would not appear to have a negative impact on the neighborhood. And with the following condition, that a restrictive covenant be signed and recorded.
I have a question.
Okay.
When must this covenant be signed and recorded?
Before the building permit is issued.
Before building permit?
Yep.
Did you make mention of the number of trailers that are on the property, or not? And then I think I talked with Eric about this last time, but I just want a clarification on the number of trailers that can be on the property.
So I believe 4 trailers are allowed for personal use. And with that variance that allowed 2 trailers, the variance granted in 2020 that allowed for 2 trailers relating to a home business at the property. Additional trailers.
So a total of 6.
Yeah.
Okay. And on pages 12 and 13 of our packet, there's pictures of looks like a single stall garage on a platform. That's permitted as part of this?
What page?
12 and
12, the shed.
And 13, yeah, there's a shed.
It's coming down, isn't it?
We believe it's coming down. The applicant can answer that better probably.
Okay. Other questions for staff? All right, is the applicant here? Please step forward, state your name and your address for the record.
Hi, I'm Kevin Rose. I live at 300 Blowers. And, I did have a question if that shed was going to be able to stay. I am removing that one trailer and currently looking at another place to park a couple of other trailers, so.
is going away. And this is what I'm talking about.
Okay. Could we have the picture on page 12 so we can make sure we understand?
I think it's page 4. Page 4.
Okay, that one. Okay. So you're saying that the horizontal one, that trailer is going to go away. State your name,
Hi,
please.
my name is Michelle Rose. I also live at 300 Flowers. I'm Kevin's wife. That picture I thought was ambiguous. We do plan on removing that trailer and the fence going to that shed, but our original plan was to keep the shed and the garage is on this side of that trailer, just to move the garage, build the garage back a little bit. Yep, towards the shed, but leave the shed if possible. If we have to remove it, that's fine too, but the original plan was to leave the shed but remove the trailer and the fence.
Is that shed on a permanent foundation?
No, it's on skids.
Okay.
Questions?
So back to my question, is the shed allowed or not?
With the square footage?
Was that factored into this?
I don't believe that shed was factored into the square footage shown in the staff report. So if you decided to allow that shed to stay as well, that would change how many square feet would be over that 1,200 limit. But we can calculate that to see how much it would be over if it was kept.
That shed is 200 square feet.
200 square feet?
Does it have to be a permanently attached building to be counted? I mean, this is apparently on skids. It'd be a portable building.
No what?
That doesn't matter.
It doesn't have to be permanently attached. It's fine to be on skids. And still counts. And it would still count.
That's what I was asking. Thank you.
Okay, so as I understand, back to 12, please. Yeah, that one, up there, yeah. There you go. So the horizontal shed container thing and the fence going to be gone, and that's where you want to put the new building?
Yes. Well,
There's
it's
no
it's
new
attached
building,
to
it's
the
attached, we
garage.
just want to extend the
gonna make the garage
garage
larger.
that's there. The
I
gray, if you
see.
go up, you can see the gray garage, which we're trying to extend this way.
That way, okay, thank you. All right. Questions?
Just about the other building.
Okay, so what would happen if, to allow for a 1508, is that right, Joe? The 200? Okay. Which would be 308 more than the 1,200 allowed, right? Okay. Craig, do you have any questions? 1508 and... Okay, any other questions? All right. I'll entertain a motion, please.
I'll move that the request by Kevin Rose for a variance to the accessory structure square footage limit to allow for 1,508 square feet of accessory structure, which is 308 square feet, more than the 1,200 square feet allowed, to allow for the construction of a 480 square foot addition to an existing accessory structure in the R2 1 and 2 family residence district located at 300 Blowers Avenue be approved for the following reasons. There would appear to be uniqueness for the request as the applicant's property is 4 times larger than typical lots in the area, and the request would not appear to have a negative impact on the neighborhood, and with the following conditions: that a restrictive covenant be signed and recorded
Before the building permit is
before
issued.
building permit is issued.
Second.
It's been moved and seconded. Any further discussion? All those in favor?
Aye.
Aye. Motion carries.
Thank you.
You're welcome. Happy Thanksgiving. Okay, our second decision tonight is a request by E&A Properties LLC for a variance to the front yard setback requirements to allow for a setback of 10 feet, 0.95 feet less than the 10.95 feet previously approved in order to construct a 9,975 square foot building in the M1 Light Industrial District located adjacent to 1825 Jefferson Street. Staff report, please.
This is Dornoff for staff. At the August 26, 2025 Board of Adjustment meeting, the board approved a variance to allow for a 10.95 foot setback. However, the applicant needed a 10-foot setback, but the letter concerning that never reached the planning staff, and the site plan provided showed a 10.95 foot setback, so that's what the staff report and the motion contain. The applicant's requesting a variance to allow for a 10-foot setback. It should be noted that the properties at 1727 and 1716 Jefferson and on the next block have a setback of 5 feet. So this one will still be farther back than the neighboring properties across the street. There would appear to be uniqueness to the request as I said, their buildings to the northwest are of West 16th Street with an even smaller front yard setback, and many other buildings in the area have smaller setbacks. Therefore, staff recommends that the request by E&A Properties LLC for a variance to the front yard setback requirements to allow for a setback of 10 feet, 0.95 feet less than the 10.95 feet previously approved in order to construct a 9,975 square foot building in the M1 Light Industrial District located adjacent to 1825 Jefferson Street be approved for the following reasons. The request would appear to have a lack of reasonable return as the applicants would have to build a smaller building, and they because they have to meet the modern stormwater detention requirements. There would appear to be uniqueness to the request since there's other buildings in the area with a smaller front yard setbacks, and there's been no opposition to this request.
Questions for staff,
Are we
please?
fixing a clerical error here?
Yeah.
Is that what it boils down to, or?
Yeah, I mean, like I said, we never received that they needed to change it from a 10.95, so we're just putting it through so that it could be properly done.
Okay, any other questions? Anyone in the audience wants to speak about this request? Okay,
Wait a minute, he's getting up.
oh, tell you what.
Nick Brewer, 12643 W Ave, Cedar Falls, representing the applicant tonight. Wasn't able to be here at that August meeting. We appreciate the variance for the 1095, but we do apologize for the mistake and that we just wanted that even, clean 10-foot setback, not a 10.95. So thanks again for the reconsideration and apologize for that error.
Thank you.
Thank you.
Questions? All right, I'll entertain a motion.
I'll make a motion to approve the request by E&A Properties LLC for a variance to the front yard setback requirements to allow for a setback of 10 feet, 0.95 feet less than the 10.95 feet previously approved, in order to construct a 9,975 square foot building in the M1 Light Industrial District located adjacent to 1825 Jefferson Street for the following reasons. Number one, the request would appear to have a lack of reasonable return as the applicants would have to build a smaller building and they need to meet modern stormwater detention requirements. Number two, there would appear to be a uniqueness to this request since there are other buildings in the area with even smaller front yard setbacks. And number three, there's been no opposition to this request.
Second.
It's been moved and seconded. Any further discussion? All those in favor?
Aye.
Aye, motion carries. Thank you. And our third decision item tonight is a request by John and Lori Leiden for a one-year temporary variance to allow an accessory structure on a lot with no primary structure to allow for the existing home to be demolished and a new home constructed by November 30th, 2026 in the R2 1 and 2 Family Residence District located at 801 Gilbert Street. Staff report, please.
This is Tamala with staff. The applicant is requesting a variance to allow a detached garage on a lot with no house on a temporary basis. The property is located at 801 Gilbert Street and is zoned R2 1 and 2 Family Residence District and has been zoned as such since 1969. The request would not appear to have a negative impact on the surrounding neighborhood or land use as the applicant plans to demolish the existing house and build another house next spring. The request would not appear to have a negative impact on pedestrian or traffic conditions in the area. The future land use map designates the area as low-density residential. The request, I believe it should say the request is in conformance with future land use map. The section of the zoning ordinance that pertains to this request, Chapter 5 General Regulations 1051E accessory structures. The applicant is requesting a one-year temporary variance to allow an accessory structure on a lot with no primary structure to allow for the existing home to be demolished and construct a new primary structure by November 30th, 2026 in the R2 1 and 2 Family Residence District located at 801 Gilbert Street. The applicants noted that they are requesting this temporary variance as they plan to start the house rebuild next spring. Applicants also stated that they initially planned to build a duplex but are now considering a single-family dwelling due to financial reasons. The applicants are now having the existing house inspected for termites as the detached garage has a termite infestation. And upon speaking to code enforcement, they did mention that the house also has a termite infestation. This is why the property had received citations from code enforcement regarding termite treatment and roof and wall repairs for the detached garage, and even before the current owners. Code enforcement has issued a citation for the demolition of the house and garage. However, since the applicants were willing to make the necessary repairs to the garage, code enforcement is allowing it to remain. There would appear to be a lack of reasonable return as the existing house is being required to be demolished by code enforcement, and a garage on a lot without a principal structure would be in code violation, but would only be in violation for less than a year. There would appear to be uniqueness to the request as it it is a temporary variance, and the applicants are currently working to build a new house. Staff has heard opposition to the request. After the packet has been sent out, we had multiple phone calls come in, all in opposition of the request, stating that the existing garage is not in a healthy condition to remain in general, and that they do not see why the garage should be allowed to be up while the house is being required to and being planned to be demolished. Therefore, staff recommends that the request by John and Lori Leiden for a 1-year temporary variance to allow an accessory structure on a lot with no primary structure to allow for the existing home to be demolished and a new home constructed by November 30th, 2026 in the R2 1 and 2 Family Residence District located at 801 Gilbert Street be approved for the following reasons. The request will not appear to have a negative impact on the surrounding neighborhood or land use. The applicant plans to demolish the existing house and build another house next spring. It's subject to the following condition: that a home is built and the existing garage is repaired by November 30th, 2026, or the garage is demolished.
Thank you. So, any of those calls that came in, were any of those contractors?
No,
Okay,
as
just
far
wondering.
as my understanding, they all stated that they were residents of the neighborhood.
Okay, thank you. Questions, please, of staff?
On page 25 of our packet, there's a picture of this garage, which makes it look better than it presently looks. Those comments about the callers, I have to agree with those folks that I don't know that this garage is salvageable.
Well, my concern when I drove out there was that the front of the garage along the right side of the overhead door area looked to me like it was pushed in. And the roof looked like it was sagging a bit. And I don't know if they've had somebody take a look at it and say that it's okay, why?
As the owner, if I were the owner and there was a termite infestation,
Yeah, it'd be gone.
it would be gone.
Yeah.
Yeah.
Any other comments? All right. Would you like to address the board? Please, come forward, state your name and address for the record.
I'm Lori Leiden. I live at 3181 170th Street, Dysart. There is not an active termite infestation. I had gone with a termite person, and he's going to treat it. I have not got that secured yet, but that's my intention. And as he said, termites are everywhere. But if you treat them and keep that treatment going, you can control them. So the damage to the garage is on it would be the south side, and there's a heaved up land there with bricks in it. So that's causing the problem. It caused the dry rot, because the termite guy said, this could be dry rot, this could be termites. So anyway, it's damaged. And my intention is to jack it up, get the plate replaced, and the studs. And that's what's causing the roof to sag, is because the bottom plate is not in good repair.
Okay.
And if that was replaced, new studs, I think it can be salvaged.
Okay.
I'm assuming you would put siding on the garage to match
Yes.
the house.
Yes, I intend to do that as well. New garage door, anything I need to plumb up or level, to get all that checked out.
Okay.
Is this rental property?
I'm doing it for my son. So yes, he's gonna rent it, but it's for him.
Okay, so you are the owner of the property and of the buildings,
I'm the new owner, yes,
but you're not going to be living there. Someone's
No.
going to be renting the property.
yes.
Okay. The new house that you intend to build, is it going to be occupy the same footprint as the current house?
Yeah, I
Smaller,
wanna-
larger?
I wanted to build a 2-story and do a duplex, but I've since changed my mind because of cost. So, but I want to build on the existing foundation.
So it's gonna, if you will, be the same, it'll occupy the same
Footprint,
footprint?
yes.
Yes, okay. If you were to change your mind and go back to the duplex option, are they then required to have 2 garages as it would be a duplex?
It's either 2 garages or 1 garage, depending on the size of the garage. So, I don't, Eric has the number with him. I don't, but I can find it. Well, that's what I'm saying. You've got the book.
Straighter with staff, I get turned to the page in the zoning ordinance. The ordinance requires for a single-family home a minimum of a 14-foot wide by 20-foot deep accessory structure. And for a duplex, it requires that you would either have 2 of those or a single garage of a minimum of 22-foot wide by 20-foot deep. I assume this building would meet that minimum 22 by 20.
Okay,
Guess I don't know the exact dimensions.
that would satisfy the duplex.
Yeah.
Okay.
Even though it only has a 1 overhead door?
Obviously, there'd be some modifications
Yeah.
to be made, but
That, again, I don't have dimensions, but that width of the door would be considered a double door. It's wider than what a single door would. Typically with that type of a style, you kind of have to drive in and then angle over a little bit to get the second vehicle in it.
so I bring that up in case you go back to the duplex option, that you're aware that you're gonna have to,
Yeah, I appreciate that. I didn't know that.
okay. Okay, I'm done.
Craig, any questions?
No.
No, you're good? All right. Thank you.
All right, thank you.
All right. A motion, please.
I move that the request by John and Lori Lyden for a 1-year temporary variance to allow an accessory structure on a lot with no primary structure, to allow for the existing home to be demolished and a new home constructed by November 30th, 2026 in the R2 1 and 2 Family Residence District located at 801 Gilbert Street be approved for the following reasons. The request would not appear to have a negative impact on the neighborhood at, or land use. The applicant plans to demolish the existing house and build another house next spring, and subject to the following conditions: that a home is built and the existing garage is repaired by November 30th, 2026, or the garage is demolished.
Second.
It's been moved and seconded. Any further discussion? All those in favor?
Aye.
Aye. Motion carries.
Laura, you understand your timeline here, correct? Yeah, I do. Okay, all right.
I wanted it all done.
Well, you have a happy Thanksgiving now.
I appreciate it.
You bet. All right. Discussion items. I understand we have a discussion item.
A brief discussion item.
Chicken.
Uh-oh, we have handouts.
It's not gonna be brief.
No.
Okay, Eric Schrader, City Planner. So, the board asked for our office to review Board of Adjustment action sunsets, or automatic terminations, as they might be called. So I provide you a handout that notes BOA action sunsets versus vested rights, because vested rights is essentially the primary concern that an automatic sunset could generate. So what is the issue? Can actions taken by the Board of Adjustment, such as variances and special permits, have automatic sunsets, where the board's approval would automatically expire or terminate without some form of action taken by the applicant that received the board's action? So reviewing existing codes, city code, the City of Waterloo zoning ordinance, chapter 28 is the section that provides the framework for requirements related to the Board of Adjustment. And this includes a provision regarding the revocation or termination of special permits after 1 year, but it's not automatic. So the board may act to revoke a special permit. There is no mention of revocation or termination for variances anywhere, and there's no other reference to any of the other sections of that chapter that deal with the Board of Adjustment on that topic. So then looking at state code.
Hold on, stop. So for any action to be taken on what you just described, a board member has to bring that back, or how does?
Based on the current wording for the potential to revoke a special permit, you mean?
Yes.
Yes, it doesn't really specify, but without any further guidance on that, yes, I think the interpretation would be either staff could determine that a request may need to be revoked and put it on the agenda of the board, or a board member could request that an item be considered to be revoked. So if we end up changing based on this discussion, that wording will go away anyway.
Sure.
But yes, if we don't, that's the existing framework, and yeah, that's how I think we would handle that.
And that's the extent of who could bring that forward, not someone from general public or whatever.
Yes, I would say if we were approached by the general public, staff would evaluate if we think, maybe we've just missed it and it's bringing it to our attention and we agree. So we would say, yeah, that seems like it should be on. Or if it's one of those where we don't think it really should, we would say you can, have a conversation with a board member to see if they think differently.
Okay.
That would be how I would anticipate handling that, but we would certainly take additional input on that as well. So then looking at state code, which kind of provides the framework for which zoning is allowed, which is under chapter 414 of the Code of Iowa, which is, that chapter is titled City Zoning. County zoning has its own chapter. But there's several sections that deal with Board of Adjustment requirements, and there's no mention of revocation, termination, anything of that sort anywhere in the state code. So then looking at other cities. So in researching the zoning ordinances of other cities in Iowa, staff found only 2 examples where they have provisions that provide some form of automatic termination of either variances or special permits. Ames and Iowa City. College towns, interesting. So Ames has a provision for the automatic termination of just special permits. So theirs does not cover variances. Iowa City provides for the automatic termination of all Board of Adjustment orders. So that would include variances and special permits. So looking at the wording of each, I've provided the exact wording in the handout, but Ames calls it a lapse of approval. All special again, theirs is just for special permits. All special use permits shall lapse 12 months after the date of issuance unless the use is undertaken or a building permit has been issued and actual construction started, where unusual circumstances may prevent compliance with this time requirement. The Zoning Board of Adjustment may, upon written request by the affected permittee, extend the time for required start of construction an additional 60 days. Excavation shall not be considered construction for the purpose of enforcing this section. And then looking at Iowa cities, notes the Board of Adjustment shall conduct public hearings and make decisions in accordance with the following requirements, one of which is E, orders lapse of approval. Unless otherwise determined by the board, all orders of the board shall expire 6 months from the date the written decision is filed with the city clerk, unless the applicant shall have taken action within the 6-month period to establish the use or construct the building permitted under the terms of the board's decision, such as obtaining a building permit and proceeding to completion in accordance with the terms of the permit. Upon written request and for good cause shown, the board may extend the expiration date of any order without further public hearing on the merits of the original appeal or application. So, kind of looking at concerns with automatic termination. So the state code wording has nothing that specifically prohibits it, which is presumably why there are at least 2 cities that do have provisions providing for it. But the primary concern would be whether or not such an automatic termination might impact what's called a vested right of an individual. So when might an individual have a vested right? So we looked at case law. There's a decent amount of case law dealing with vested rights. Did not find any that are specific to Board of Adjustment action, but there are ones that deal with vested rights based on changes to building code requirements and zoning requirements. And a variance is a form of a change in the zoning requirement. So the case law would appear to be relevant. And then in the handout, I noted a bunch of specific cases that we were citing. So just kind of summarizing that case law, actions of a city, such as issuance of a building permit and presumably BOA issuance of a variance or special permit, could result in an individual having a vested right based on that action. And the word could is emphasized here as it is clearly not an automatic does result in a vested right. And the specifics of a particular action that would lead to a vested right is fairly complex. Depends on quite a few variables, and ultimately it's going to be up to a court to decide. So, however, based on that assessment that a BOA action could result in a vested right, that could mean that an automatic termination, or a sunset as we're referring it as, of an approval of the board could impact someone's vested rights. And if someone has a vested right based on a BOA action, then either the city would be stopped or prohibited from revoking it. Well, from a legal standpoint, that might be after the fact, after the board would revoke it, but or would be liable for a takings, which would be monetary damages for the taking of a vested right. So when might a BOA action become a vested right? In a 1998 case, which was Quality Refrigerated Services versus Spencer, the Iowa Supreme Court determined that a developer acquired a vested right to proceed under the old ordinance, which could be the equivalent to a previously approved variance that has sunset. So they acquire a vested right if, one, they make substantial expenditures toward the development prior to the zoning change or prior to an automatic termination, and two, those expenditures were made lawfully. Another factor that could be relevant is the legal doctrine called bad faith. Citing a 1999 Iowa Supreme Court case, which was U.S. Cellular versus a Board of Adjustment, the court determined that the Board of Adjustment denial of a request which was without any legal justification for an application that clearly met all of the requirements of the then existing ordinance requirements was illegal and therefore acting in bad faith. So the question is, could an automatic termination of the approval of an action be in bad faith if the original approval was considered to be complying with all of the requirements, and then it sunsets, it would still technically be requiring with all of the elements, or is the fact that the applicant or impacted party had time to take action under the approval, and then their failure to do so, would that eliminate any bad faith? There is no known legal precedent to address that. So I think it would probably be mitigated by the time and option to take action, but again, no clear case law on that. So wording to help avoid vested rights or a bad faith claim. Both the City of Ames and Iowa City have somewhat similar wording that provides limitations to automatic termination. Iowa City's includes the phrase, unless otherwise determined by the board. meaning as part of an approval, the board could specify an alternative expiration date or provide that there be no such termination date or expiration date. And both have wording that addresses if the applicant or an impacted party takes action such as establishing the use that a BOA approval covered, or constructing the building that a BOA action addressed, or obtaining the building permit to start construction. All of those things would kind of provide for an automatic termination to then not occur. So just kind of in general review, although there are legitimate concerns that an automatic termination of approvals could cause some legal issues such as vested rights, it would appear that those issues can be mitigated by, one, providing a reasonable time before an automatic termination occurs, two, providing limitations to when an approval would not automatically terminate, and three, providing an avenue where the allotted time can be longer or extended in unusual circumstances. So in particular, the Iowa City wording that the board can extend the expiration date without further public hearing on the merits of the original appeal or application seems good. So you don't essentially have to rehear the action, you just have to decide if it's appropriate to give an extension. The Ames wording of excavation shall not be considered construction and is also good, as we would not want someone to move a few shovels of dirt and then expect to say that, hey, we've started, so we're good. But at the same time, there could be a development that requires substantial grading, and that might be looked at as a start. Oh, Iowa City's time period of only 6 months does not seem very reasonable, so we would definitely not recommend, if we proceed with any changes, that we would go with that. There's an untold number of reasons that it could take an applicant longer than 6 months to start a project after BOA approval. Oftentimes an applicant is waiting to start hiring an engineer and developing plans until a BOA approval, because developing those plans can be costly. They may not have all of their financing in line and don't want to start that until the BOA approval. An approval right now, we're heading into winter, so all of those reasons, I think 6 months is definitely way too short. 1 year is probably pretty reasonable. Could see an argument for 2 years, but that's probably a little excessive. So the next steps, if there's consensus of the board that actions should have some sort of automatic termination, then if yes, what are some of the provisions and specific wording that the board likes, and what would you like to see? And then also, if yes, the process would be staff would prepare an amendment to the zoning ordinance. We would, of course, review this with the Board of Adjustment, but the official approval process for a zoning ordinance amendment includes recommendation by the Planning and Zoning Commission with final approval by the City Council. Was that brief enough?
Pretty darn good. So,
I have a question for you.
I assume there would be some.
everything you presented has to do with special permits.
No.
It also applies to variances.
Yes.
Okay. And the reason I ask is, and the reason he's doing this is because I asked, back in 2020, we approved someone to develop condos off of Martin Road on the Irv Warren Golf Course. That has never happened, never. So it's like, okay, has that approval been, died? Or is it still, can someone still go in there and do as proposed?
And the
That
answer is
was-
yes, they could, because under current provisions, variance runs with the land. So yeah, you, without any, either specific action of the board to terminate, like the special permits have that provision right in there, but you could, in theory, initiate a termination of a variance too. There's nothing saying that you can't, but so that would be potential one. If we don't change anything, that's one option, is to just initiate action on a particular request to terminate the approval. It'd be a little bit more complex, I think, but.
So if Builder 1 gets approval to do these condos, and that never happens, can Builder 2 then come in and do it, or do they have to go through a separate process?
They do not. Variances are considered to run with the land regardless of who owns them. So that example, or take, pretty much any other example, but I'll use the very frequent one that we get is a variance to build a garage or build an addition to a garage that exceeds size, exceeds height, whatever that case may be. Once that variance is approved, yeah, the current property owner could not build it, could sell the property 10 years later, and the new owner could build that based on that approved variance. Yes, without doing something to provide an automatic termination.
Okay, so there's the background as to why we're having this discussion, so.
I have a question for you, actually, a couple of them, but the first one, your answer to the first one might be, might eliminate the rest of them. But anyway, we're talking, when we say within a 12-month period, they have to start construction, but we don't have a completion date.
Well, that would depend on how you word that. Let me get my cheaters back out here. Yes, not every, Mr. Bozen commented a development agreement would have that expiration date, but yeah, not all projects involve a development agreement. A lot of the stuff that you see for variances does not.
I'm thinking like, and I have no reason to suspect anything like this happening, but for an instance, like the lady that was here for item 3, she could tear down the old house and frame up a couple walls, and that would be considered start of construction.
Right, so
And could she sit on that, working on it for another 2 years after?
that would depend on how if we added something, that would depend on how we word it. The Ames wording is not very good, in my opinion, from that regard, because it just kind of talks about building permit has been issued. Well, maybe theirs is fine because because it says actual construction started. So they pull the permit and start construction. Under the Ames wording, in theory, they could do that, extend that out for several years. Yes, and then the Iowa City one has a little bit better wording, and it talks about building, and so applicant shall have taken actions within 6 months to establish use or construct the building permitted under the terms of the board decision, such as obtaining a building permit and proceeding to completion in accordance with the terms of the permit. So that's the key wording there, in accordance with the terms of the permit. Yeah. A building permit is valid for 180 days to begin construction. I'll have to double check with the building department, but there is a time period of which once you have started, that it would expire. Other than they do consider, if you are continually making progress, that it will not expire. So from that respect, I could see if we're going to do something, we do some wording like Iowa City, but you may want to put in some drop dead deadline, but not to exceed 2 years or something like that.
Well, and I guess I'm just looking at also at when might a Board of Adjustment action, then either the city would be, sorry, I'm on the wrong line. When might a Board of Adjustment action become a vested right? One of the things that we had down here is if they make substantial expenditures toward the development prior to the zoning change.
Yeah.
What's a substantial expenditure?
That's going to be up to a court to decide as well, but my guess is it would probably be some sort of weighted relevance to the cost of whatever was approved to begin with, right? So let's say you approved a variance for a 200 square foot shed, and a typical 200 square foot shed, costs $800 and, you know, and they say, well, I've invested $100. Is that substantial compared to the overall cost versus someone that gets a variance for a building that's going to cost $1 million and they've invested 100,000, you know, from a percentage standpoint, they might, you know, be even less of a percent, but it's a pretty substantial investment. So what an actual number would be, I don't know. It would ultimately be up to a court. But the other thing is a lot of these will talk about, you know, you pull a permit and start construction. That kind of saves you. Well, there certainly are instances where you could have a substantial investment before you have pulled a building permit or started construction. And a real great example of that would be someone that is looking to buy a property, but they can't build what they want to do. So they do a purchase agreement subject to getting the variance approvals that they need. And then in that situation, maybe the existing owner is the applicant or the proposed buyers are the applicant on behalf of the owners. Either is considered acceptable, but either way, the person looking to buy the property is going through that variance process before they would have purchased it. So then if the variance is approved and they proceed to purchase it based on the knowledge that that variance was granted, that would be a substantial investment and a vested right. Now, how long do they have to take action on that vested right? If you give them a reasonable amount of time and it's clearly stated up front that here's how long it's good for you to get it purchased, get a permit, and get construction started, does that, you know, address that? And you've got, you know, therefore your vested right has gone away since you didn't act within the clearly stated reasonable time given.
Okay.
Let's use item number 3 on our agenda today for the example. I mean, that includes an end date of November 30th, 2026.
Yeah, that one does.
Is this something that we should consider maybe building into these variance and special permit request? I mean, it appears there on this one.
It certainly can, but so we call those temporary variances, and there are certain types of requests that just lend themselves very well to a temporary variance, and that's usually the surfacing. The zoning ordinance requires vehicular use areas to be hard surfaced, and hard surface is defined as Portland cement concrete or asphalt with very specific definitions of what it has to be and thicknesses and all of that. And we, you know, semi-routinely get requests for variances to go with something else, whether that be gravel, recycled asphalt, and we fairly typically will grant those on a temporary basis because they have plans to do that next step, build an addition there anyway, which is going to take it out, or the gravel is going to become the base for the pavement that then's put on over the top. The garage on a lot by itself, the zoning ordinance does not allow an accessory building on a lot without a principal permitted use. In other words, no garage without the house. Again, not uncommon that we will do a temporary variance based on the fact that they're going to build a house, so it's only going to be non-compliant for a short period of time. Other variances, like I'm going to build an addition to my garage, you know, we wouldn't normally attach a timeline on that because those temporary variances, as we normally word them, the whole thing goes away. There is no more variance, and at the end, it has to comply. Whereas like with the garage addition, you know, once it's built, it needs that variance forever. It's going to forever not comply with the stated requirements of the ordinance for whatever reason, size, setback, height, whatever the case may be. So what you're talking about, you know, rather than a temporary variance until it must comply is just a limited time period that the approval is good through. We could do that. I would say it might be better off just doing something like one of these to put it right in there, but if there's not consensus on that is another option. Don't put anything in the ordinance, or put it for special permits. Special permits are a little different than your typical variances. You know, you have a special permit for a religious facility in a building, and 3 years later it's not there. Does that make more sense for that to automatically terminate, so that 10 years later someone doesn't put it in there and we realize there's other issues that weren't thought of, so that it should have to come back through an approval process?
Case in
So I
point
think
would-
special permits are which is why there's the provision that's not an automatic termination, but at least gets you thinking that it could be terminated in there. If we don't put in automatic termination for variances, then yeah, that's something that on a case-by-case basis, maybe you're like, all right, this is one, or I think we better put a time frame on it, and after that, it automatically terminates. But that
So if
would
it's
be an
not
option.
presented as such in the packet we receive, we can do that during the hearing for that variance. We can say that we would like to put an end date, if you will.
I believe you can. I'm aware of no ordinance, state code, or case law that says you can't.
Okay,
Could be into the takings issue, but again, I think those issues are mitigated by being reasonable and providing a reasonable time period and ways that they can avoid that. Start the construction.
okay.
I want to build on what you originally said, the condos at the golf course. So it's been a while. If someone purchased a property and the variance was available, must they use the same plans and all, and the whole site layout, all of that? Or is that up for renegotiation as well?
So I would say yes and no, depending on the specifics of the variance. Typically, a variance isn't really going to be design specific, so like those type of things on how it looks wouldn't come into play. Sometimes your variance is going to be very specific on a size, so
Or
then
number.
right, so then that would come into play and it would have to match that. Oftentimes, your variance is going to be very specific on a setback, so that would still come into play. But, you know, let's say that they show a plan that's showing 5 2,000 square foot buildings with a variance to the rear yard setback of 10. If they come in and build the 5 units at the 10-foot setback, but build 3,000 square foot units, that would be fine, as long as there wasn't anything as part of that approval that tied it to that size.
Okay.
Go back to your church example. We approved quite a while ago for a group to go in and convert the roller skating facility on Black Hawk Road into a church. Never happened. So it's just things like this that, you know, we give the approval and then nothing happens, and it seems like it's something that should be cleaned up.
And probably well over 9 times out of 10, it never comes back up again and doesn't really matter.
Yeah.
But there always could be that 1 time out of 10 where, yeah, years down the road, it does happen. We wouldn't have anything to be able to block it. And does it cause issues? It could.
Like I said, when I approached this to you, it seems like we should have some shelf life on these things.
Does this cause extra staff work for a thing that may or may not happen?
Well, we will have to write an amendment, and as part of that, you know, we've got to be very detailed on how we do that to ensure we stay compliant and proper references to the ordinance and all of that. So there would be some staff time in doing that. At the same time, it's, you know, how often it comes up, sure, that could be in question, but, you know, if it avoids one problem, it could be well worth it.
Did you, when you were doing your research, did you inquire about that? Did you talk to somebody in Ames and Iowa City to see how they do the tracking and the particular file?
Adarsh actually did the research. Do you want to comment on that?
This is Tamala with staff. With Ames and Iowa City, they didn't really go into specifics on how they were tracking it, more or less if a variance comes in, and they have that 6-month period. I believe Ames is 6 months.
Iowa City.
Iowa City is 6 months. Then if they do get the building plans and site plans for final approval by the planner to sign off within that 6 months, and then they start construction, I believe they're just going by the timeline of how these projects usually transpire, is they'll come with a certain site plan, they'll need a variance, and then once that's approved, they'll submit the final site plans for review. But they didn't really go into if they had a certain tracking system on, if they were maintaining certain databases or logs to routinely check up on them.
Interesting.
It's worth inquiring. I mean, especially from those concerns, you know.
Yeah,
Okay. Thanks.
yeah.
Thank you.
And Schrader with staff, just as a follow-up to that, we've created a tracking log for the temporary variances that we do grant. So something like this would be very easily just rolled into that if we did start having automatic terminations. Because, yeah, I would think, you know, we would want something that basically tracks approvals that are deemed terminated. You know, once something's built, and you know, then it's fine.
Sure.
Yeah.
All right. Thank you.
Thank you, that was very interesting.
Thanks, Eric.
Okay, now, speaking of temporary variances, bring you up to date where we are there. We are actually all up to date on temporary variances. We had 3, now we're gonna have 4 coming up next year, but they're not, 1 in September, 1 in October, and now 2 in November. So as far as, I know John asked about Sager, they have properly hard surfaced, they've removed the gravel, and so yeah, they are in compliance
Compliant.
now. The container at
Our
the on
RPM,
Thornsdale,
RPM? I think it's
Yeah.
RPM Motors.
yeah, they have been, it's in, code enforcement's working on that. There was also the garage at 258 Western that they never built the garage until they were taken to court, and they have now built that garage. So, yeah, we're now fully caught up.
Great.
It's amazing how the Islamic Center came together and made that happen
Yeah,
after
twice.
so many years.
Yeah. All right, well done. All right, the next thing on our agenda is the election of chair and vice chair for the term ending December 31, 2026. Open for nominations, I guess.
I would make a nomination for Ms. Thornsberry to continue as chair.
I will second that.
All those in favor?
Aye.
Aye, motion carries. Thank you very much.
I will make a nomination that John Beckman continue to serve as vice chair.
Second. All those in favor?
Aye.
Aye.
Aye, motion carries. Thank you to us.
Thank you.
Yes, congratulations.
Yes. All right. Motion to adjourn.
Motion.
Second.
Moved and seconded, we are adjourned.